You're welcome back. This is Newsfile, it's your most authoritative news analysis platform. And here on Newsfile, we put Ghana first, as we always do. Dr. Kojo Pumpuni Asante with the CDD Ghana. He is in charge of Director of Advocacy and Policy Engagements. Nana Ejay Bafo Ewa and Sulemana Brahima, Executive Director, Media Foundation for West Africa. Gentlemen, good morning. Thank you for making time to join us.
Good morning, my brother. Thank you very much for having us.
Great. Okay, so let's begin with you, Nana. If you can spend about 3 minutes, 4 minutes, give your preliminary thoughts. But you could go for the jugular. What is it about this judgment? 67 pages. What is it about this judgment that gets your attention? You can try to do sort of an introduction, giving us your list of things you want to speak about and, you know, a summary of each point, and then we will come back to go deeper into them. So let's begin with you.
Good morning to your cherished listeners and then viewers. I've gone through the judgment,
right,
and I think that the amount of work the judge did is what catches my attention. I mean, if you compare what the judge did, very respectfully, to some of the decisions of the Supreme Court on the same subject of defamation, I think that this is more thorough, with all humility, to the judges of the Apex Court. The way he set out the law, for me, is quite interesting. Trying to determine which law he should choose in determining this matter. For me, very respectfully, I think that was a bit unnecessary. That part was a bit unnecessary, but it doesn't change anything. He ended up applying the law as sanctioned by the Apex Court in as the law that governs the resolution or determination of matters of this nature. And so for me, it's the detailed work, the detailed analysis, right? That for me, you know, catches my attention with respect to what the judge has done. When you look at his evaluation of the test that governs cases of this nature, that is defamation, he seems to have given, you know, some spread by way of a dimension to even the test as sanctioned by the Apex Court. When you look at the cases of Owusu Domina, Professor Adekule, Adekulu, Abena Pokuya, Aka, and co. If you look at all, the Supreme Court seems to have, you know, crystallized the learnings into 3 guidelines or 3 requirements that ought to be satisfied. But he seems to have broken down an aspect of it. That is, if you look at what Justice Benin wrote in Owusu Domina, he sets out 3 guidelines and says that where the word is capable of defamatory meaning, it actually means that it's defamatory. But when you read the literature on what constitutes or how to determine whether or not a particular statement or publication is capable of defamatory meaning, is the perspective of the what do you call it, the reasonable man or the right thinking member of society. He seems to have incorporated that into another leg, or stood on that as a basis to break that particular requirement as to whether or not the word is capable of defamatory meaning, right, into whether it actually defames the person. So it is not enough that the word is capable of defamatory meaning, right? But whether or not there's a reason why it should not actually defame the person, or there's a reason why it should actually defame the person. So I think that what the judge did, Samson, when you read this judgment, I think it's a very thorough judgment.
Okay, so you take a pause there. Yeah. You take a pause there. We'll return to you. He says that, the judge sets out comprehensively what the law or the rules are that must be applied in determining a defamation suit. He has used what the Supreme Court has set out and what we already know, the 3 guidelines, in determining such cases as crystallized by the Supreme Court. And he is particularly, happy about his attempt to show that something may be capable of defamation, but has it actually led to defamation, or has it actually defamed? He is also interested in that as well. Well, now let me hear from Dr. Pumpuni Asante. Yes, what catches your attention in this decision?
Yeah, good morning, Samson.
Good morning.
So I think for me, what is on trial, at least in the eyes of the public, because we are all not lawyers, and most people come to this subject matter with much more broader perspectives than maybe lawyers would take it. It's not just a defamation suit. It's whether or not Anas Aremi or Anas, celebrated, investigative journalist who has risked his life in many different ways across many societies, not just in Ghana or Africa. Anas has even done cases in Asia and so on. Is in fact a blackmailer, an extortionist, a murderer, a corrupt person, a thief, and the list goes on. That this guy, this young man who has been doing this, to uncover all kinds of criminality in society, is in all this while a criminal himself. That is the big question. And this is a question that Mr. Kedijapong, since he started with the Who Watches the Watchman, video, has tried, to maintain. And then it has come, and then that was played out, for the public on many occasions to debate and discuss. But that whole debate and discussion has now been brought into the prism of a defamation suit. So we get to almost kind of relitigate this matter. But it is fundamental. I mean, for those of us who work in the governance space, who work in the anti-corruption space, this is important. We are talking about one of the foremost anti-corruption, actors in our space, not just in Ghana, but in Africa. So for me, that is the question. But the other thing on trial is analysis method. And people call entrapment, there's a sense of fear that if something like this is allowed to stand, then particularly Ghanaian elites cannot sleep in this country or anywhere in Africa, including presidents and so on. So because of that, what stands out, at least from a legal perspective, is the determination of facts in this case, particularly the determination of facts that lead to a pronouncement on criminal conduct. And that is where there's some very interesting determinations, which I'm sure we'll get into it. But that's for me when I look at this, and I think for most people who want to resolve this matter, this is the issue that is on the table for us to address.
Okay. Thank you very much, Dr. Kojo Pumpuni Asante. He's also a lawyer. Now, let's hear from Suleiman Ibrahima, the non-lawyer among the lawyers, but the man who is involved through the Media Foundation for West Africa in training investigative journalists. As far as we know in this country, it is their, organization that has been involved in deliberately grooming people to become investigative journalists. And that's where Manasseh Azuri also work. So, Sule, let's hear what you think. Dr. Kojo Mpunia-Asante says this is what is on trial is whether Anas is what the MP for Asin and the judge are set in this judgment. And more importantly, whether the Anas's methods, and I know you don't like Anas's methods, is also on trial, but he's concerned about whether or not the criminal pronouncements made in the civil suits is proper in this matter. So he'll come to explain. But Sule, what do we hear from you?
Well, thank you very much. So as you rightly say, I'm a non-lawyer, and so I look at it from the ordinary man's perspective. Of course, we are told that the law is not English, even though sometimes we read it and understand it from the perspective of, understanding the words in their ordinary sense. But at least I should understand, at least from the basic point of view, what defamation is supposed to be. If I were to take someone to court on the basis of defamation, I am saying that the person has said, uttered, or published something that undermines my reputation, my character, and in the eyes of the ordinary man on the street, portrays me in a way that, brings my reputation down. And I suppose to a large extent, that is really what this whole thing was about. And us going to court to say that this person has said a number of things, uttered a number of things, published a number of things about me, which undermines my integrity, my reputation, and in the eyes of the ordinary man, really impugns and dents who I am supposed to be. As far as I'm concerned, that fundamentally was the issue before the court. And if you look at what the court puts forward as the issues to be determined, I think it really ended at that. Now, you look at Anas's claims and what he says as plaintiff. So the person says, I'm a criminal, I'm a thief, I am an extortionist, I am a murderer. And from the ruling, the defendant admits saying all that. Says, yes, I made all those claims, but I would prove that what I said, they were true, they were justified, and they were fair. And so when I was reading it, I was following it that way. I said, oh, okay, this is going to be interesting. I'm going to see whether or not it was proven that these claims about Anas being a thief, a murderer, whatever it is, how was it proven in court? So I go on, and then, of course, the judge then establishes what defamation is supposed to be, what the clear defenses are. And, of course, as a non-lawyer, I understand, reading it. But as I go along, I got to a point, and something I exclaimed to myself, hey, am I not following them? Have I read something wrong? So I went back to about 3 paragraphs up to read again. Then I told myself, no, okay, that's not it. Because I saw a clear instance of, the whole case moving beyond whether or not Anas is established, whether Kennedy Japan was able to prove that Anas is a murderer, a thief, extortionist, a bribe taker, a criminal, to the judge examining the methodology Anas uses and whether or not journalistically that is appropriate or not appropriate. And then I asked myself there, oh, was this judge a journalist before becoming a judge? Or was he maybe an academic in the media sector before becoming? Because clearly he was trying to establish what is right, what is wrong, to the point where he then goes on to say what is being practiced is not investigative journalism, but something else. So for me, I think that the judgment or the decision by the judge went beyond probing whether what Ken said was true or not true, justifiable, fair, and whatever, to actually himself defaming the character of Anas. But of course, this was in court, and I doubt what can be done to a judge. But I believe that if this was being said on the streets, that would have amounted to another instance of defamation. But I guess we would, as time goes on, we'll get some of the issues.
Right. Thank you. Thank you very much. So now, Nana, I'll come to you. And the point that you make, is it not a given that when a judge is going to give a decision on defamation or in any other case, they will set out what the principles are, what the law is. Normally, they will discuss the law and then apply it to, the testimony, the evidence, so to speak. So what is, as you put it, what is extraordinary about all those lengthy pages of, explanations as to what law must apply, what constitutes defamation, what is not defamation, what is extraordinary about that, and why should that, take our attention in examining this?
Samson, it's just to let you know that the decision was not in a vacuum. Plain and simple. It wasn't in a vacuum. It was based on the law, and that the law has a defined basis for what constitutes defamation. Defamation. And so, therefore, the decision was not in a vacuum.
Okay.
Secondly, when it comes to judgment, you and I know that it is not always that judges get it right. And so, therefore, sometimes even references to the law might be wrong. And so, if the law is set out right, we must commend a judge for doing that, because then we know that he was going, on the basis of established principles. He was not committing an error of law, right? And so for me, I think that in that regard, he has to be commended.
Okay.
Now, what people don't, I appreciate the point that Mr. Suleimana just made. I think that I've also seen comments to the effect that, comments on social media to the effect that Anas went to a civil court and came out as a felon. And I also get that. It is because, some of our colleagues, as they rightly admitted, they are not lawyers. And so some of these things they would not understand. It is possible to make claims that have criminal connotations, right, in a civil matter. And when that is done, and when you look at the judgment, the judge analyzed that and said, page 10 of the judgment specifically, he analyzed that and said that when that is done, then the burden is one which is required in criminal matters. That is beyond reasonable doubt. The judge alluded to all those, or looked at all those in his decision.
Great. Right. So if you can hold on there, where it says he's a tax evader, does the judge show you where this is proving in the trial that Anas evades tax?
Samson, you have to go to the position of the law on what constitutes defamation to have a good appreciation of this.
No, I want us to look at this.
Wait, Samson.
No, Samson. Wait. Just a second. Let's go for the jugular, just a bit. I'm saying that you say criminal matters come in, and that's correct. You're right. We all know, we are taught that there can be pleadings about criminal, claims in a defamation suit, but in a civil suit. But whereas if it was a pure civil suit, the proof, the burden is that of preponderance of probabilities. When crime comes in, the proof is, the standard is one of proof beyond reasonable doubts. So like you mentioned from Sule, I think what Sule would need from someone like you is to understand when the judge holds that he's a tax evader, as has been said by the person he has brought to court, when he talks about he's an email hacker, for example, do you find the proof? When he says he's a murderer, do you find the proof for it? Or there shouldn't be? When he says he's a fraudster.
It's very important that in dealing with these matters, we look at what the judge said in terms of what constitutes defamation. Samson, it is not enough to say that the word is capable of defamatory meaning. But as to whether or not it actually defamed him is another thing altogether. The judge may not have considered all the things which Anas alleged that Kenneth Japon stated, for which reason he deemed to be defamation. He may not have considered everything. However, the judge looked at the whole statement in its totality and reasoned that on the basis of some admissions, I've come to the following conclusions. Now, if we isolate what the judge did not say or what the judge said, we miss the point. We need to look at whether on the basis of what transpired, all other things, right, would mean that Kenneth Japon has defamed Anas or not. Now, the reason why he went to court, right, all the words the judge used, words the judge used, for which some people find, or for which some of us may find unpalatable, they were not conjured by the judge. Anas himself had gone to court to say that these are statements that have been made against me by Kennedy Japon, which I find defamatory. Right? Now, Kennedy Japon comes to court and say, yes, I stated all these things.
They are true, they are justified, they are fair.
They are true, they are justified. Right? Now, the next question then will be, there will be no need for the judge to determine whether or not those statements were made against Anas.
Yeah, because he has already admitted.
They've already been admitted. And the judge said it, that once something is admitted, there's no need to prove same.
So you are saying that there's no need to establish, when he says my defense is truth, justification, which is saying is truth, there's no need to establish that when I say you are a murderer, you are in fact a murderer. When I say you are a tax evader, you are in fact a tax evader. When I say you are email hacker, you are in fact an email hacker. There's no need to prove it.
No, Samson. There's the need, there may be the need to prove it. However, the judge will first have to determine whether or not it is capable of defamation. And that is where the judge said that in the case of the late MP, J.B. Dankwa Edu.
That's right.
Right? There was somebody standing trial for the murder. So the fundamental question is whether or not, in the wake of all that, whether the right-thinking member of society will think that Anas actually killed J.B. Dankwa Edu. So the judge analyzed all those things. That somebody has been arrested, somebody is standing trial for the murder of J.B. Dankwa Edu, right? And then Kenneth Japon has said he killed J.B. Dankwa Edu. In court, Kenneth Japon said no, because he had said, I killed Ahmed Swale. I also said he killed J.B. Dankwa Edu. So in court, Kenneth Japon did not say that the statement that Anas killed J.B. Dankwa Edu was true. He only said that, yes, I also said that because he had made a similar allegation of murder against me. At that point, Kenneth Japon didn't have to prove the truth of that statement. The question is whether or not, in the circumstance of it, right, will the ordinary, the right-thinking member of society come to the conclusion that indeed Kenneth Japon meant, or actually meant, that J.B. Dankwa Edu was killed by Anas. For which reason it will lower his...
Question. After after the judge speaks, the judgment speaks about that, you know, a criminal, murderer, evil person, thief, a cheat, fraudster, extortionist, blackmailer, corrupt, land grabber, tax evader, bribe taker, giver, interferer in administration of justice, terrorizes people, email hacker, among others. Then it says, the failure of the defendants, that is the MP, to plead and provide evidence on those matters only meant that the words were admitted by him sub silentio, as in he's silent about it. He doesn't need to actually say that, you know,
that's right,
one thing or the other, but I have admitted them by not saying anything. Then he says, he has admitted them this way as having been uttered by him, that they were uttered in reference to Anas, and that they were published. Then he says the point that you make about what the judge said about it. The judgment says, as already mentioned above, it is the burden of the judge as a trier of fact to determine whether the words actually defame the plaintiff using the hypothetical reader test. And then he comes to say, I have concluded aforehand, based on exhibit so and so, that the plaintiff, Anas, engaged in the crime of bribe taking and bribe giving. A person who commits a crime is a criminal, simpliciter. However, since every word uttered in a different occasion, on a different occasion, ought to be assessed for their defamatory effect, I'll assess all alleged words to determine if they succeed in actually defaming the plaintiff. Then here is the point you are making. He says, on the allegation that plaintiff murdered former member of parliament, Joseph Boachi Dankwa Edu, is consorting with his wife and was responsible for the killing of some Chinese. Defendant explained under cross-examination that he said so because plaintiff had alleged that he killed his colleague, Ahmed Swale. The hypothetical reader would have read about the notorious case involving the murder of the former member of parliament, Mr. Boachi Dankwa, and would be aware of the trial of the suspects, which excludes Anas, the plaintiff. The allegation made by the defendant could not therefore succeed in actually defaming the plaintiff. This is what you say, that should end it.
In my humble opinion, you see, the judge did not make the statement in a vacuum. Samson, he based it on the evidence, exhibit KA01, KA02, KA03, and KA04.
Stay with the issue of murder. Is there an exhibit about murder?
Samson, if you limit, you need
no,
to
I want us to isolate them because this is an important part of it. You have referred to exhibit. When it comes to the murder, do you see an exhibit about murder? I mean, let's just deal with this first,
Samson,
and then
did the judge make a finding of Kenneth Japon having justified the murder based on the exhibit? He didn't.
Okay.
He said that. Samson, he didn't. He said that when you look at the allegation of murder, one Kenneth Japon had said that he had said so in rebuttal to a certain allegation. That's the first point. The second point the judge made was that the trial of J.B. Dankwa's murder, the accused person, right, for J.B. Dankwa's murder was ongoing.
That's right.
And so therefore, the reasonable man or the right-thinking member of society who knows that there is police, the police has investigated the matter. 3, the police has somebody who has been charged for the murder.
Right.
4, that person is standing trial for the murder.
Correct.
5, whether or not in that circumstance, right, the right-thinking member of society is likely to say that what Kenneth Japon is saying is true or not. At that point, the judge concludes that on the basis of these facts, right, the right-thinking member of society is likely to come to a different conclusion.
Okay, so the question now is, the question now is this. what do you say to members of the public? And this has become an important part, as you have seen being discussed in the public. As a lawyer, bring your experience to bear to help them appreciate. What members of the public are saying is that this is illogical. They are saying that if the man says, what I said was true and is justified, and you have found that, in fact, there is somebody standing trial, and that person standing trial is not Anas, then it means it is not true what he said about him. If it is not true, what should happen? What will you say to those who are saying differently?
So what I would say to those who are looking at it from a different perspective is that, yes, words may be capable, words may have may be capable of defamatory meaning. Not every word which is capable of defamation actually defames, and it is so because the circumstances, right, that surround it may cause a right-thinking member of society to think otherwise, even though somebody may have stated so, right? And so the fact that Kenneth Japon may have called Anas murderer doesn't necessarily mean that everybody will believe it. And as the judge explained, because of the circumstances, the right-thinking member of society may not believe it.
The right-thinking member of society will say that that allegation is not true.
Yes, because the right-thinking member
if it is not true, if it is not true, then it's not justified. It's not fair. You know,
then it means it is. Then it means it is not defamatory because it does not actually defames. And that's why I said to you, look, when you look at all the literature on defamation, Samson, when they are looking at the right-thinking member of society, they are not just looking at you or I. Right. Or Mr. Suleiman.
Okay.
They are looking at people who are capable of
so Nana, thank you for that. Thank you for that. I'm bringing this in. Wait, just a second, because you know we are dealing with time and we have to be careful. Now, in the same vein, we'll come back to particularly Exhibit KA01, which is actually the main thing that the trial is hinged on. Yes. The issue of, because I sit here and I have to reflect what the public is making. Then we'll come to the end, whether it is justified, how some are using this to want to say that they don't have trust in the judiciary, if it is fair at all. Like Manasseh says, it's not at all. When he says he's an email hacker, when the judge, the person accuses somebody is an email hacker, he is, what do you call it, tax evader, he's a land grabber. You are saying in the same way, there's no need to prove that as being true, even though the defendant says it is true. Yes, Nana. I can't hear Nana. Hello? I don't know what's going on. Okay, so whilst we try to get Nana back, Dr. Santi, hello? Hello, Dr. Santi. I can't hear Dr. Santi too. Hello?
Hello.
Good.
Okay.
So on that issue of the murder and the examples I'm giving, tax evader, email hacker, land grabber, from your reading, what do you say to the criticism from the public?
So, yeah, thank you very much, Samson. And, you know, this particular issue for me is important, and I take cognizance of the fact that Anas and his lawyers have released a statement that they are going on appeal. So, again, it's not to litigate these matters on radio, but I think because this is so central, and my premise or my preamble, you know, to this discussion was that, you know, from a governance perspective, from an anti-corruption perspective, this conviction in a civil trial is important because it's a court of records, right? What the judge is determining as fact is important for whether the public can walk away from this judgment and say, we know as a fact that Anas is a blackmailer, he's a thief, he's a murderer, all those things that have been said. And I start from the judge's own sort of setting out the legal tests that have to be applied when you are making a determination on criminal conduct within a civil trial, where he says, where a party alleges the commission of a crime by the other in a civil suit, the standard of proof is the same as the criminal case, a proof beyond reasonable doubt. But then he makes a further statement that in a criminal case, the rule has crystallized into a voluntary confession. I think section 120 evidence, where he's talking, where basically in a civil suit, the way in which you determine whether that criminal conduct has been proven is that if the person makes a confession, then basically that is enough, right, for you to say the standard have been met. So he lays this out. And then in his determination, as you say, so that the first piece of evidence in this KA1 exhibit is whether to determine whether or not Anas is the person in the video or not. Can you hear me? Hello?
Yes, I can hear you, Doc. Can you hear me?
Yes.
Yes, Doc, I was hoping that we could distill this in a certain fashion so that so that our audience can follow us.
Sure.
You see, when it comes to the video,
yes,
which is exhibit KOA1,
yes,
that is, we can deal with that.
Sure.
I'm talking about where the court refers to a question of murder, for example, and gives you why that should not, be an issue for him to prove anything. And
but that would be contradictory to the legal test that the judge himself set out, which I've just read to you. That where you allege the commission of a crime, that it has to be proven on the standard of beyond reasonable doubt, or a self-confession. Now, the evidence that the judge relied on in this case, there was no self-confession, and there was no evidence led to prove that this has happened. And as you said, there are many things that have been said, including the murder, the tax evasion, the killing of Chinese people, all of these things, where there was no evidence provided. Now, if the suggestion is that in a defamation case, if you call me a thief and I call you an armed robber, then basically we strike each other out. Because that's in the reading of the judge, it sounds like that's what the judge is saying. That it's not defamatory because we basically call each other names.
Yes, but in law, in the heat of anger, in defamation, in the heat of anger, when you exchange words, vituperation could be said to not be defamatory.
But this is the defendant has admitted that he basically is setting out to prove these things that he has said it. Of course, in the murder case, for instance, in the one that he's talking about, Jamie Dankwa, he says, well, I also called him a murderer because of that. But it doesn't extend to whether that also means that the Chinese people that he supposedly had killed is also related to that same matter, or whether he doesn't even mention the tax evasion or any of these things. So I think that's why, for me, as I said, the judge's effort to determine facts in this case is quite interesting, because it raises so many red flags in my mind, because it's not consistent with even the way he's laid out the law itself. So at least on that matter, for me, I feel that the job was not done. I mean, I don't see how you kind of move from the test, the legal test, because this is still criminal conduct that you're talking about. Remember that in the determination that he's made, anyway, and we'll come to KO1, he has convicted other people apart from Anas.
Okay, so hold on. We are going there, so don't go there.
To that.
Yeah,
we'll come to that.
Yeah, so Doc, hold on there. Let me go to Sule now. Sule, you brought this up about you said failure to prove his defenses. I mean, largely that's what you said. Your reading of what happened appears to suggest to you. So on this leg, what's your appreciation? And you have listened to first Bafor. These are lawyers. You have listened to Kojo Asante. You are no lawyer. How do what they say help you appreciate what you find difficult to believe, just as some members of the public are using and saying this, particularly the analogy about the murder thing, the land grabbing analogy to that there was a judgment already which was in favor of Anas, but which judgment was quashed by the Supreme Court and so on. Yes, let's hear you.
Well, I think listening to Bafor raises a lot of curiosity for me as a non-lawyer, because at some point it sounds as though if you were to say certain things damaging about an individual, yes, it could be established as damaging words that undermine the reputation of that individual, but may not be defamatory. The second point is, well, if you say 10 things that are, negative, damaging about an individual, then you go to court and you are able to prove 1, 2, or 3 of them, the judge could then say, well, on the basis of this 1, 2, 3, even though I have not been able to provide defenses for the others, I don't think that those ones could be defamatory. The other point is that to say that because somebody is on trial, it could then be concluded that even if the person made words or said things that undermine or impugn the reputation of someone, given that somebody is in court and on trial for that same offense, the person could be exonerated. In other words, if somebody is on trial for a particular offense, I can then accuse Dr. Kojo Asante as an offender in that same thing, and then when it goes to court, I need to just basically point the judge to the fact that, oh, somebody else is on trial for that offense, and it is because Dr. Asante had accused me of a certain crime. That is why I also made that claim or defamatory statement about him. It also sounds to me as though it's okay to make defamatory statements against an individual, and then when you are sued before the judge, you you offer an explanation as to why those things were said. Oh, he stole my plantain, that is why I also stole his plantain. Or he called me a thief, and that is why I also called him a thief. And then, given that somebody is on trial for that, then it's okay. I find it quite curious. And when the reference is continually made about the ordinary man on the street, right-thinking people on the street, I wonder who those right-thinking people on the street would be, because I consider myself to be one of them. I am not a lawyer. I consider myself as somebody who is interested in this. And when Ken says Anas is a murderer, killed J.B. Dankwa and is consulting with the wife, in my view, I was looking for, is it true or is not true? Okay, this matter is before court. I'm looking forward to whether it will be proven that Anas indeed had a hand in the murder of J.B. Dankwa, and whether or not indeed he's having an affair.
J.B. Dankwa and Chinese.
Yes, J.B. Dankwa and Chinese. I'm looking forward to evidence to that effect. And to say that, well, there were no defenses to that, but on the basis of other things, the defendant wasn't deemed.
Don't you think that on the basis we can move to exhibit KOA1 now, which I'll start from with Nana Bafo, but you don't you think, for example, that since the judge has seen what he has seen in the footage, which he takes as fact because he's exercising it, and okay, so this is not funny, but I told a client once many years ago that when we are going to the court, the judge doesn't know the truth. It is you and your other side who know the truth, or God who knows the truth. The judge will only determine what he has to determine on the basis of what you say and what the other person say, and the evidences that you bring. What he comes to may coincide with the truth, but the court doesn't know the truth. Now, he has seen a video and there are things in there. Is he not entitled to say, by this video that I have seen, that you are promising to give a bribe, that you have already given a bribe? If somebody says you are a tax evader, email hacker, or whatever you are, I should use that basis to believe that these things you are capable of them and therefore you are not defamed. Doesn't it apply somewhat? Sule, your basic thinking doesn't work?
Not at all, because Samson, you see, the very, very last paragraph of the ruling, the judge says, I state in conclusion that whereas all the statements founded on exhibits KOO1, KAO2, KOA3, and KOO4 were truthful and factual, thereby sustaining defendant's defense of justification and fair comment, the statements in Plaintiff's Exhibit C, though capable of defamatory meanings, were not proven to have actually defamed the plaintiff. I found the claims of plaintiff meritless, and I hereby dismiss them. So, in conclusion, it was on the evidence of the contents of for easy pronunciation, KOA 1, 2, 3, and 4. And as you said earlier, these materials did not contain anything about somebody being a hacker, somebody being a murderer, somebody being a killer, somebody being a tax evader, and so on and so forth. So if the holistic conclusion was based on the content of KOA 1, 2, 3, and 4, then on what basis were those other ones not deemed to have been defamatory?
Okay. All right. Thank you. Thank you. Now let me go to Nana now. And interesting things. Dr. Asante, I know, and we will come to you because you guys as CDD are looking at policy questions, and that's the major reason you are on the show this morning. But Nana Bafo, Nana J. Bafo, why am I always trying to mix it? Nana J. Bafo Ewa. Now, can we go to the exhibit you referred to, and then on that basis, explain to those who share a different view and want to fault the judgment, and you seem to want to say, there are questions of trust with the court. Can you use that to explain?
Okay.
Yeah.
For me, Exhibit KO1 is the most important evidence in this whole trial.
That's right.
Is the most important evidence in this whole trial because it relates to Anas's professional work as we have come to know him. And all the allegations of murder, tax evasion, and all those things, for me, in my humble opinion, if Anas was not an investigative journalist of the magnitude that we have seen in this country, it wouldn't have been important to me. Exhibit KO1 concerns the credibility of Anas's work, his integrity as an investigative journalist. And I thought that is what would take center stage, right? You and I know that Samson, judges in their line of work, right, have the right to have it right and also have the right to have it wrong. That is why there is an internal curative system, that is the appellate system, for correcting the rights or wrongs of judges.
That's right.
And all those issues, in my humble opinion, are very insignificant. For me, KO1 is very fundamental.
It is.
From the judgment, and the name of the game, as you know in trial, is evidence. Evidence evaluation is judged or determined by the Evidence Act. There are rules to it. And so therefore, you cannot simply go to court and say that a particular exhibit which somebody has tendered, that exhibit is merely doctored. So it's merely doctored.
So Nana, let me read what the summary of sometimes you see KA01, sometimes you see KOA1. So let's, I'm referring from the certified copy of the judgment. So it refers to it as Exhibit KA01. And it says, Counsel for Plaintiff sought to explain away the apparent meaning, scope, and effect of the recording in Exhibit KOA1 concerning the plaintiff. According to him, Exhibit KOA1 comprises 2 videos made by the plaintiff, that's Anas, and his Tiger IPI team in 2009. The first part concerns a conversation pursuant to a contract by one Zachary L. Venegas between the Anas and the suspects in the $1.9 million gold scam case. The strategy of Anas, he claimed, was to engage in a free and open conversation with the criminals so they come out with all implicating facts that could then be used against them. The second part of the video involved a meeting between Anas. When I see plaintiff, I put Anas just for the purpose of easy appreciation by our viewers. That's the second video, involved a meeting between Anas's team and the prosecutor to narrate their investigations and engage in a pre-trial preparation for the trial. According to counsel for the MP and his team, put the 2 audiovisuals together, edited, patched up, and superimposed same with ill-faith commentaries. To buttress his submission, he referred to the prosecution proceedings of the trial, admitted as Exhibit F series, which proves that Anas was attending court and duly testified to assist in the successful prosecution of the accused persons, contrary to the claims of the defendant. He also referred to Exhibit E and F, by which as a result of a communication between Anas's counsel and the Attorney General, it was made clear that nothing in the records of the trial indicates that Anas could have colluded with the prosecutor to botch the trial. I don't know if I read the correct portion, but it gives you an idea of what is involved in that exhibit, where in that video, which is Who Watches the Watchman, played by the defendant on his TV station, in taking it as it is, Anas, somebody said to be Anas, the court believes that is Anas, is heard actually saying that he has paid bribes to the CID and he has paid bribe to the prosecutor, and he took about $100,000 out of which he was making these payments and so on. Yes, Nana, now you can continue.
Now, Samson, one key fact about Exhibit KO1, as you have rightly described, is that Anas's lawyers never disputed the fact that Exhibit KO1, being the video recording of what the judge considered to be confession of bribe taken, right, by Anas, was never denied. They never denied the fact that they generated that video. It was never denied.
Were they right to demand that it should not be patched up videos with jumps in it, but it should be the raw footage before you can admit it, because it's not authentic and original?
The fundamental issue when it comes to admissibility, is whether or not it is relevant to the matter at hand.
That's right.
Once it is relevant, it is admitted by the court.
They are arguing that when the state is using ANAS for trials, when the state is using ANAS to help them to prosecute people he has found to have done wrong, always the court demands the raw footage, not just the few minutes that have been pieced together. And they are saying that somebody has doctored. So where you hear ANAS, quote unquote, the person said to be ANAS, saying that I took this money and I gave this person so amount, it is possible that that was somebody else superimposing a voice.
Very respectfully, I appreciate all those facts. So if you allow me, will be of more help to your listeners and viewers. They never denied as a fundamental point that that video was put together by ANAS. So then it goes into evidence, right? Now, what do you do as a lawyer who has had such a key evidence admitted, right, into the record of the court? Because don't forget, once the evidence is admitted on record, the court has no choice but to evaluate it. The next level then is, what weight is the court going to attribute to such evidence? Is the court going to say that merely because you say it is doctored, I shouldn't give it weight? No. You should do more as a lawyer. If you say it's been doctored, why do you say it is doctored? Have you produced a forensic evidence before the court that confirms that it's been doctored? No. All you said was that it is doctored. But the fact remains that you generated that video. And so where is the original? The original is in your custody. The original too you did not produce. What do you want the court to do?
Okay, so Nana, that point to
please,
wait. Just hold on. Okay. We don't have time. I'm moderating it. In the next 2 minutes, I'll let some other people speak. But here's the point. They say that if you say we have to go and bring the raw footage, it's wrong. Because the one who has brought it, it's his duty to bring the raw footage, not piece footage. And they also say that, why is it that the person who is speaking, the voice that is speaking, they challenge you that it is not ANAS. And nobody has been able to say that that is ANAS. ANAS's witnesses are asked, is that ANAS speaking? They say no. So how do you come to the conclusion that that is ANAS when you have not seen ANAS yourself?
Samson, in the courtroom, it is not conjecture. It is evidence. It's on the preponderance of probabilities. Once I produce evidence, I've discharged my burden. Evidence that has been admitted, I've discharged my burden. The burden is now on you to produce a contrary evidence and not merely shout that this is doctored. Anybody at all can go to court and say this is doctored. If you say it is not ANAS, where is ANAS? The judge, from the onset of his analysis of the evidence, said that at all material times, processes that ANAS's team had filed admitted to the fact that ANAS was the one on the video. Now you go into the witness box and you say that ANAS is not the one on the video. Clearly, you suffer credibility deficit, a huge one from the outset. Now you want to say that the court should take it that because of your mere shouting that it is doctored. No, that is not how we conduct trials, right? Trial is a very serious business. If you say that it is not you, produce contrary evidence, especially since it was not just an oral testimony. This is material evidence, video. You have to produce something. Otherwise, if the court will prefer, that is the position of the law, unless there is something contrary on record, the court will prefer that to your oral evidence. And so the judge was right.
Right. And then what they have put in the public also include a 5th of July 2021 record of proceedings in which they attempted to, as it were, put in evidence that suggests that the video is discredited. And that evidence, documentary, was rejected and marked as R. They say that shows you that there was an unfair process, that we are trying to question the credibility of this, and it's said to be brought by a certain Salis newspaper, and we have evidence from their side to do, and then you reject that evidence. What do you say about that?
Samson, you know the rules that govern admissibility, right? The judge did not state why at that point he didn't admit it in the judgment. So we are not able to comment on the reason behind the admissibility, the rejection of that evidence, right? But Samson, when you look at all that transpired, okay, the judge did say that, or did capture in his evidence, a dialogue between Anas and the prosecutor, where they were talking about bribe given and bribe taken. What do you want the judge to do at this point? What conclusion do you want the judge to come to? Secondly, the other video where Anas was in conversation with Mubarak and Tunde, where they discussed the possibility of exchanging money so that they would not be included in the prosecution, right? It turns out that Tunde and Mubarak were excluded from the prosecution. Samson, if it walks like a duck, quacks like a duck, right, and cries, it quacks like a duck, then it is a duck.
Okay.
Why?
Thank you. We have very limited time left. Sorry, hold on there for me. Now, Sule, I'll get you to come in briefly. Then I go to Kojo the lawyer, and bigger issues of policy that he also wants to raise. What do you make of that portion when you read through it? What do you make of it? Particularly their claim that this is pieced together and the voices appear to jump and it's very clear. So what you would do is have the full footage and not this piecemeal. Yes, Sule. Have I lost Sule?
Can you hear me, Samson?
Yes, please.
Okay. Yes, so I read about that contention in the ruling, and the judge rather says that if the claimant or the plaintiff is saying that it was a doctored video and couldn't also then submit the original, then it is difficult for that to be accepted. But like you said, in all trials and cases involving Anas, there's always been the point about we need the original. And in this case, therefore, one would have been expecting that the judge would have then said, okay, unless the judge says, no, I don't take it to be doctored, or the evidence adduced to make the point that it is doctored wasn't adequate enough, then the judge would have said, okay, we need the original version of this to be able to authenticate whether indeed this is pieced together or not. But for me, the whole thing is quite curious. And one cannot but say, can we take this matter a step further? Because really, as I said from the beginning, it moves beyond the whole question of establishing defamation, getting into issues of criminal conduct and all of that, journalistic methodologies, and it certainly would have a significant implication on journalism in this country. For example, the judge, in the matter of J.B. Danko Edu, the judge simply makes references to the fact that somebody is on trial. The question is, has the person been proven guilty? Tomorrow, assuming tomorrow, that guy who is on trial is said to be innocent and not involved in that. Wouldn't the right-thinking people on the street then think that, okay, then, as it was alleged, then it must be Anas who did this? So there are a lot of questions in relation to this ruling, And I'm happy that I'm hearing, I'm here to speak to Anas about it. I'm hearing that they are thinking of filing an appeal, and I think that would be the right thing to do.
So you say from where you sit, your concern is that this will have an impact on investigative journalists, and you are training investigative journalists.
Absolutely, yes. We have debates and we have questions about the matters, but no, I mean, just like this decision, we are debating it, and that is how we improve a profession. If we are all to say, okay, this is the way to go, then certainly I don't think that we would have a development in the particular profession. Okay. It is right to debate, to argue about theories, to argue about matters, and that is how we evolve, change things, amend things, and so on. I cannot say I am right.
All right.
I cannot say this is right. Okay. But to now make this ruling on defamation.
Okay, so let's go to Prof. Dr. Kojo Pumpuni Asante. Doc, let's hear you on this and the questions of policy and journalism in general that you are concerned about.
Samson, for me, and I think from the beginning, what concerns me is really the criminal conviction and the treatment of facts by the judge. And everybody is right in the sense that the whole decision, even on the defamation, is hinged on this KOA1 video. And the KOA1 video starts, first of all, with the question about whether Anas is in the video, Anas is not in the video. And in the judge's discussion, he says, well, in the cross-examination of Anas's lawyers, at one point they said Anas is not the one in the video, but at another point they said Anas was the one being referred to. I didn't understand why the judge found a confusion with that. Of course, the video, it shows a picture of Anas. They keep inserting a picture of Anas, and there's a commentary that says this is Anas. So it's Anas being referred to. But they are right in saying that Anas is not the one in the video. How that resolution leads to in the court's judgment, a deliberate attempt to mislead the court by this so-called contradiction. Now that then moves to say that any activity in the video involves Anas. So Anas is meeting with people to plot this. Anas is meeting with a prosecutor. So for me, we are talking about a criminal conviction, which is supposed to be a standard of proof that is beyond reasonable doubt. If this is how the treatment is done to arrive at a certainty that a video that the defendant brought, that he says it came from Silas newspaper. So by that understanding, Silas newspaper has the original. The person doesn't produce the original, produce what they have pieced together. And on that basis, you say, well, it's the plaintiff that has to bring the original. So there is a lot of contention around the evidence that is used to convict in this manner. And I feel that if you are going to, because this is a serious, for me, by this, you have convicted Anas of a serious crime, a number of crimes. You have convicted the former CID, Director General of the CID, Mr. Dupoku. You have convicted the lawyer, Mr. Kokume, right, by judicial record through this analysis of facts. And I find that there's no way in my humble estimation that you can treat a criminal process like this in this way. So I find a lot of problems with it. So on the policy side, as I've said, there are issues that are raised about analysis methods and so on and so forth. And the debate goes on. I have always erred on the caution that a lot of the things we experience in Ghana, in Africa, and it's not just across the world, that there are many issues around corruption that you have to use subterfuge to get to the matter. And often when it happens, it will lead to an investigation, a substantive investigation, like in the FIFA case.
Okay.
It led to a substantive investigation, and then it helps society to address these problems in society.
All right. Thank you very much. Unfortunately, this is all time will allow us. But as we understand, Anas has issued a statement and says that he intends to appeal the decision for a number of reasons. Let's see how that goes, because that is actually what should happen. If you disagree with the judgment of the court, you should go on appeal. I wanted us to discuss the other aspect about people making the commentary and trying to, like Manasseh put it in what I read to you, that there is lack of trust in the judiciary. But I'm sure that the explanations that the lawyers and all of these have brought in helps you to be able to take a decision based on this and make it independent of the entire judicial system. But I'm sure that we may have to discuss further these matters going forward. My outfit, as always, is by Habil Scooter. You can find them at Ajiringano Gate, East Legon. You can call them on 0200 84 1988. This has been Newsfile. It's your most authoritative news analysis platform. And my guest for the final segment have been Suleiman Ibrahima of the Media Foundation for West Africa, Dr. Kojo Pumpuni Asante of CDD Ghana, and Nana J. Bafo Ewa, Senior Partner, Sarkodie Bafo Ewa and Partners. I'm Samson Ladi Ayenini, and I invite you tomorrow afternoon, Sunday, on this same network. Join my guest Dennis Ejei Jumo and Hanifa Ajoayaya to discuss invalid Islamic marriages. The Registrar General says that 80% of the marriages conducted in Islam are invalid. What are the consequences, including property disputes coming forward? Have a good afternoon.